Good morning, everyone. Thank you for joining us today. My name is Dr. Clifford Deal. I'm the president of the Medical Society of Virginia. We are broadcasting live from a secure, undisclosed location deep inside Henrico. We have a two-part webinar planned for today. For the first half hour, we'll be joined by Scott Johnson, who will share information about the liability coverage during COVID-19. And then from 8 to 9, we'll be joined by two speakers, Angela Navro, Deputy Secretary of Commerce and Trade for the Commonwealth of Virginia, and Cynthia Brown, Vice President of Government Affairs at the American Medical Association. They will be presenting information on financial assistance programs to support providers during these financially difficult times. I'll introduce our second half speakers in a bit. If you're able, we encourage you to stay on the whole time, but as always, we'll be recording and posting the webinars on our website, msv.org/COVID-19. To kick us off, I'd like to welcome Scott Johnson to the webinar. He is a partner at Hancock Johnson and has served as the General Counsel of the Medical Society of Virginia. If you have any questions for Scott, please feel free to type them up in the chat and we'll do our best to get your questions answered. If we don't get your questions by the end of the call, please email them to governmentaffairs@msv.org. All right, Scott, it's all you.
Well, good morning, everybody. Thank you for joining. We put together a PowerPoint to walk through some of the liability issues because clearly we've been getting a number of questions. We've been working very hard on the issue of liability, and so I just wanted to walk you through a lay of the land on what statutes Virginia has, what requests we've made of the governor, what is out there if somebody is being asked to volunteer as a healthcare provider. So that's where we'll go, and I'll be glad to take what questions you have. So we're going to move to the next slide, please, Taylor. Great. So we have two statutes that are in place in Virginia. This first one, 8.01-22501, has been on our books since 2003. And a lot of times when you talk about immunity issues, you have immunity in place and it only applies if somebody is not being compensated for whatever they're doing. We have these two statutes that we're going to go through that are not tied to payment or compensation. These immunities apply to what we refer to as simple negligence, which is basically a garden variety personal injury case, a regular medical malpractice case. We do not have immunity for gross negligence or willful misconduct. That basically is a situation where someone intentionally does not do what the standard of care requires or acts with a willful disregard. Unfortunately, those are rare and far between. But basically what this statute addresses is if you have a disaster and a healthcare provider is responding to that disaster and is not able to deliver care to another patient, which they have a duty, they would be granted immunity for simple negligence if there's been an emergency declaration and you're not able to provide that necessary health care. Now, lawyers love to play with words, and this statute is valid, it's solid, it's good, but it has never been interpreted since it was passed in 2003, as best we know. And so if you were finding yourself a defendant in a medical malpractice lawsuit and your attorney raised this, the attorney suing you and your lawyer would tease through all the different phrases in the statute and would ask questions along the lines of, is COVID-19 a disaster or is it a virus? Is a virus the same thing as a disaster or not? And work its way through that. This was designed for the situation that a physician had an office full of 20 patients to see and had to leave those patients to go respond to whatever the disaster is. And as a result of that, one of those 20 patients had a heart attack in the office and died, or had some illness that was not able to be treated, like cancer, and there was a delay in diagnosis. As long as that was your patient and you had a duty, it provides you protection in that category. It's not a blanket protect you from everything. It's very, very specific as to what it does cover. We'll move to the next screen now and talk about the second statute. This statute we've had in Virginia since 2008. It also provides limited liability or immunity protection from simple negligence, does not provide any protection for gross negligence or willful misconduct. It has not been interpreted, as far as we know, by any court, and this approaches it a little bit different. This addresses a situation where you have a disaster, you're responding to the disaster, you're delivering health care or you're withholding health care. And as long as you do that, as long as a disaster has been declared by the governor or subsequently declared by the governor, and the emergency had a situation where you lack resources like PPE, then you could argue that you're entitled to immunity protection under the statute. Again, none of the phrases in here have been connected. There was a question raised when you look at this and say sometimes you may be delivering or withholding care given the circumstances you have, and it may not be as a result of lack of resources, as you see phrased in the statute. So because the former statute we just talked about has not had a court interpreted, because this one has not had a court interpreted, we will talk with you in a few minutes about a request we've made of the governor. So these two situations only apply to healthcare providers. In Virginia, healthcare providers is a defined term and it's very broad, but there are a number of individuals or entities that are not included in the definition of healthcare provider. So if you are an assisted living facility, you are adult daycare, arguably some of the home care and some of the hospice are not included in our written statutory definition of healthcare provider, as opposed to many of you consider them that. So one of the issues that's been brought forward to the governor is give similar type protections to those individuals, even though they're not under the definition of healthcare provider. All right, let's go to the next slide. So the first two we just talked about, it doesn't matter if you get compensated or not. In Executive Order 42, our governor has laid out our emergency plan for the state. And that has been in place for a number of months. And when he declared the COVID-19 emergency in Executive Order 51, he basically referenced back to say, hey, trigger the emergency plan that I've laid out in Executive Order 42. And within that order, the paragraph that we pulled out, and it's a very long executive order, but the key paragraph we wanted to share with you is this paragraph provides immunity protection for simple negligence. But on the third line down on the screen, you see it applies to those individuals that are providing care without compensation. And you've heard the call from many folks to volunteer in the volunteer medical corps. And if those individuals are providing services without compensation, they would be entitled to that protection from simple negligence, the same way it would if somebody on their own decided to go volunteer delivering health care at some point in our state in response to the emergency. But again, this one is limited only to those people that are not compensated. They do permit payment of actual expenses. So if somebody had to have a hotel room, got mileage reimbursed, had meals paid for, that's not going to contaminate your immunity protection under this. Okay, let's go to the next slide. So what have we done for you? A number of healthcare associations have been working very diligently in the recent 10 days to draft a request of the governor to enter an executive order dealing with liability and protections. And you see the link on this particular slide. That will take you to the MSP website where you will see the letter to the governor and you will see a draft executive order. Many of the physician specialty groups have lent their name to this, as well as the Medical Society, the Hospital Association, the Nursing Home Association, the Virginia Nurses, Physician Assistants, NPs, a very, very broad group of folks that say, Governor, use this as an opportunity to, in large part, one, extend the immunity protections to those people that are not healthcare providers by definition, who we really think they are, assisted living facility. But more importantly, two, interpret some of those phrases that are in our two statutes that we went through to clarify that, yes, COVID is meant to be a disaster. Yes, here's what an emergency means in order to address some of that. One of the key things that we included in this was a request that we put in the executive order language addressing what is commonly known as a crisis standard of care. So when we talk about immunity, that basically means if somebody sued you for simple negligence, you'd be able to raise that statute to the judge and say, Judge, dismiss this lawsuit. And you never get into the question about whether you complied with the standard of care or not. We don't have anything in our statutes that speak to crisis standard of care. Other states have commented on it. Other states have had governors included in an executive order. But basically, I think of it in the category of you're doing the best you can with what you have, and that's what you ought to be judged by your peers as they review the work you did. And so that has been an aspect of what we have requested of the governor. The other complement that we have looked at is a number of physicians are having to treat their non-COVID patients differently because of COVID. And you've seen the examples of treating patients in a physician's parking lot of the office because you don't want to contaminate the office, you don't want to contaminate your staff or you or your other patients, but really the care that you're rendering is something routine and basic, whether it's an examination, immunization, or whatever. We have tried to make sure that the request of the governor addresses what you're doing with those non-COVID patients as opposed to what you're doing with your true COVID patients as we look at that. But I would encourage you to look at those two things, and that request of the governor went in on Tuesday of this week. All right, let's go to the next slide. Thank you. So of interest, the day that we made the request of the governor, we get contacted by a representative of the Virginia Trial Lawyers Association. They had looked at other states, and probably somewhere in the ballpark of 20 other states have had their governors issue an executive order on liability. Some of those states don't even have the basic statutes like the first two I shared with you. So they really had to start at ground zero. And so the trial lawyers here had contacted us and says, we would like to work with the healthcare community on the issue of immunity. We have shared with them the letter that was sent to the governor and the draft executive order. They have offered some suggestions. We are still talking with them, but it is a unique situation because there's been a long-standing history in Virginia of the Trial Lawyers Association working with healthcare providers. That is not the norm. That is not what you'll probably find in any other state. But I think because of how we've approached it in the past and what the General Assembly has directed us, it's been key. Dr. Deal, I'm going to answer two questions that we got overnight, so I apologize for jumping the gun on that. And the first question we got was liability related to telehealth or telemedicine. And you may have heard me say this before, but I suggest that you look anytime when you're doing telehealth or telemedicine, think of it as a three-legged stool, and you have to address all three legs on the stool to make sure you're in good shape. The first thing has got to be making sure that you have got the appropriate licensure. Second is addressing issues of reimbursement, because depending on who the payers are, there are different requirements there. And then on the issue of liability, you want to make sure you know what your liabilities are and what your coverages are. So the first question that I had is, you have a Virginia licensed physician that has a patient in another state, say Maryland, Texas, wherever it may be, and they want to be able to provide telemedicine to that patient. And so your first question needs to be, whatever state the patient is located in, will that state require licensure of you as a Virginia physician? There are some opportunities because of this COVID disaster to say you may not need a license in the state where the patient lives. There are other situations where they have an expedited process to get a license in that state where the patient lives, or they may be silent, but you have to ask licensure first. Reimbursement, whoever is providing coverage to that patient, their rules of what's required to get reimbursed is an issue. The third issue is liability. Generally speaking, once you outreach to a patient in another state, you have subjected yourself to the jurisdiction of that state, meaning the courts have control over you. And so if you had a Maryland patient and you lived in Loudoun County and you, through telehealth, provided care to that Maryland patient, and something went south, if all of this immunity that we're working to make sure we've got in place for you, if that were to evaporate or something was to go wrong, what would dictate liability? And generally it would be the law of Maryland, meaning we would not have our medical malpractice cap. And two, our Virginia liability statutes won't apply to Maryland. Maryland's liability or immunity statutes would apply. And a lot of the other states, as I mentioned, have either statutes or have an executive order. So the analysis has always got to be those three steps. And the last piece on liability, if you've got any questions, make sure you contact the Medical Society Insurance Agency or your med mal carrier directly. It's a whole lot easier to ask up front, and we are glad to help in that regard. So Dr. Deal, I'll hand back to you to see if you have other questions.
Scott, you said there was one other question other than telehealth that came in overnight.
Oh, I'm sorry. Yes. So the other question is, what happens if a physician in Virginia is delivering telehealth to somebody that is a non-COVID related patient? And generally it is the same type of analysis. Do I have a license or need one in the state where that patient is? What are the requirements for whoever's providing coverage for that patient as far as reimbursement? And just being mindful of what your liability risk may or may not be as you go through that. So the analysis is really the same. The only distinction would be with whether this is a COVID patient or not. If you're providing telehealth and that patient's in Virginia, again, you get the benefit of the med mal cap, you get the benefit of the two statutes we talked about, and hopefully the governor will issue an executive order that would be beneficial as well.
Scott, one question that's coming in on the chat is, well, what are the likelihood, if you were handicapping the race, whether the governor will actually execute the executive order or not?
Truly in the category of guess, but in the category of experience, I would think if we could find language that is amenable to the trial lawyers, and given the broad breadth of unity in the healthcare community asking for this, I would think, what does the governor have to lose by not issuing it? It brings clarity, but I can't speak for him. I can only encourage him, and I've told him it's very much needed, and it's not just an ask to be asking. And when you look at our other states that have taken that lead, Virginia doesn't like to be first, but we don't want to be left out.
Thanks, Scott. All right, one of the questions that's coming in from the chat really has to do with the workplace. And the question is, if you're providing care in your office and one of your staff becomes ill due to the lack of appropriate PPE, so I think the question assumes some causation and has a fatal outcome or serious event, are you as the practice owner liable?
So a lot of the workplace injuries, whether it's a finger stick or non-COVID stuff, if it's an employment situation, in other words, you employ the nurse or you employ the office staff, generally any liability on the employer is going to be covered by workers' compensation insurance. And early in this COVID outbreak, I was contacted by a claimant's attorney. That's an attorney that represents the employee, the injured person in workers' comp. And we were discussing COVID, and the general rule in Virginia with businesses is workers' compensation does not cover ordinary diseases of life. And I know many would argue that COVID is not an ordinary disease, but again, lawyers like to play with words. And the concern was that if you had a person in your office and they contracted COVID, regardless of what the cause may be, that probably would not be covered by workers' compensation. And the concern was, where then would the employee turn? Because somebody's got to pay medical bills, somebody is going to be incurring lost time from work. And at this point in time, there's really no answer. I think his comment to me was more of a signal that when we get to the 2021 General Assembly session, or perhaps if we have a special session called by the governor, there may be attempts to amend or revise what are ordinary diseases of life in Virginia for workers' comp. Our firefighters and our police officers have presumptions, certain types of cancer, certain types of heart conditions, but there is nothing like that for any type of nursing personnel or any office personnel that work for a physician.
Thanks, Scott. All right, so another question is, can you get a verbal waiver for an out-of-state patient to be governed by the laws of Virginia, presumably through telehealth?
A verbal waiver would arguably be an oral contract, and contract actions are not governed by our medical malpractice cap here. So you may be able to get one. Would it hold up in court, and would it give you the protections you're looking for? I think that would be suspect.
All right, next question just has to do with the in the state, out of the state. So does the out-of-state concern apply if they're a resident or another state, or if they're a Virginia person who just happens to, say, be in Pennsylvania?
So I can answer that more from our Board of Medicine here. So say a resident lived in Potomac, Maryland, and was a student at Virginia Tech, and their primary care physician in Maryland got a call from Virginia Tech, and they were saying, I've got a sore throat, I think it's strep throat, I need an antibiotic, can you call that in? The Board of Medicine here is generally taking the approach that as long as there's an established relationship, we're okay with that. Other states, as I understand it, and I haven't researched it, realize if you're there on a vacation or short travel or had to do something, as long as there's an existing relationship, they are not going to come after you or put your feet to the fire if you're providing that care. But if it is something that's ongoing or the magnitude of care that you're giving is not something that's pressing or urgent, yes, you could have liability.
So a couple of questions have to do with physicians providing care outside of their areas of expertise. For example, if you were a GYN providing minor care in the emergency department, or somebody working in an EICU or something like that, in terms of I think the statutes.
Yeah, so our statutes right now pretty much are silent on that. And if we are successful getting the language in the executive order from the governor regarding crisis standards of care, I think that's going to be broad enough to address that. Because when you look at deploying workforce, you've got to do the best with what you have. Our regular standard of care in our code today for everybody in the non-emergency setting basically says you're required to do what a reasonably prudent physician in Virginia would do by somebody in the same or similar specialty. So there's a slight bit of flexibility there, but I think really getting that executive order would help that particular question.
One question, of course, is that does this apply to federal healthcare workers?
Now, the liability as to them is governed under the Federal Tort Claims Act, and so you've got to look to that and look to any action that Congress may take regarding that. The drafts I've seen of various pieces of legislation in Congress, the thing that I've seen addressed so far is only the volunteer situations where you're providing care without compensation. And as I mentioned on the third slide that we went through today, Virginia already has that addressed. It certainly can't hurt that Congress may come back in and help strengthen that even more, but I've not seen anything else.
A couple questions, Scott, have come in about, do hospitals bear liability if they mandate that we provide care without adequate PPE?
You know, that question is really open-ended. I've heard that posed several times, and I think that's yet to be determined. We don't have clear guidance. I'm not aware of anyone pointing out any similar types of suits that have been brought in any other states or where judges have ruled on that. Certainly from where we are and what's being reported, Virginia may be one of the first states to handle that.
So thank you, listeners and callers. If you can use the chat box to continue to ask any questions that you might have in a few minutes, we're going to transition over to our other speakers. Clark, is there anything, or Lauren or Kelsey, any other questions we're not covering that you have had come in overnight?
No, sir.
One question is, let's see, can you direct us to experts in neighboring states to help us interpret the liability rules there? I know we were on a multi-state call last night where various states were discussing the liability rules. But can we put on our website or direct people those to maybe the appropriate state medical associations links for the neighboring states?
Dr. Deal, this is Melina. Yes, sir, we'll do that so everybody can see that. And our surrounding states are on top of this as well and will be useful resources.
All right, any other questions for Scott? Let's see. Has there been any flexibility using HIPAA compliant apps for telehealth?
Dr. Deal, I may have to defer that question. I have not seen any. I'll take a look at that, and if it is, we'll post that on the MSP site.
Good. I thought I'd read something about 2 weeks ago where the HIPAA rules had been relaxed by the office of whatever the particular sub-office of the sub-office of the sub-office was that governed that, allowing you to use various audio-visual communications, but we can look into that and put that in.
We have seen some relaxation where audio-visual is not required, and in essence, a regular phone call is. And you're right, that did come out, and we'll get that posted.
Clark?
Yes, sir. To Scott's point, the CDC did put out guidance a week or two ago, loosening HIPAA as it relates to audiovisual telehealth, specifically mentioning audiovisual services such as Apple's FaceTime and things like that. It is already on our website, msv.org/COVID-19, and we can be sure to highlight it coming out of this webinar. But as always, with all things, find it before you do anything. Find it, read it, consult with a lawyer, and make the best decision possible.
Dr. Deal, also the March 19th provider memo that Medicaid sent out in Virginia, which is also on the website, has got some verbiage in there regarding the relief that they have granted regarding the facility site and what they will permit. That would be another resource to look at if you have a Medicaid patient.
So that's going to about wrap up this first half an hour. The Medical Society is very concerned with maintaining financial viability of practices across the spectrum from small to large. And this is clearly the slowdown in elective visits and visits, frankly, across the board is having a tremendous financial impact. So in the next half hour, we're going to ask, let me see, Angela Navarro is going to go first. Angela, are you on the line? We're a little bit early. Melina, is there anything you want to update while for the 2 minutes until she comes on?
I can't think of anything at this point other than just to talk a little bit more about the other states. We are working and looking at all of what other states are doing and questions coming out of other states. We are looking across specialties. We're working with the AMA. We're working with BDH just to try to keep a scan on trends and see if we can stay ahead of it and ask planners, carriers, et cetera, to go ahead and move in Virginia to what we're seeing would be better and easier and more applicable for the situation. So we're trying to be proactive. Any questions or ideas that people have on those fronts, as we get them from doctors, we start exploring them. So don't hesitate to ask if you have a thought. Virginia, as Scott says, is ahead in a lot of ways in this, and we're following where it makes sense as quickly as we can. So share your ideas.
All right, let's see. Is that Angela? Not quite. Clark, anything else we ought to be covering for a minute until Angela comes on?
No, I will just repeat the plugs Melina's already mentioned. If you have any questions regarding COVID-19 or the MSP response to it, please visit msv.org/COVID-19. We know there's a heck of a lot of information out there, so So do the best you can. And if you can't find it on there, you can always email one of our staff or at the Government Affairs inbox, which is GOVT Affairs at msv.org. And someone on our team will get back to you probably within the hour or 2 hours, tends to be our turnaround time. So we're working as fast as we can to answer as many questions as we can. So we appreciate it very much.
For an up-to-date on the granular level of where we are for the bed and ventilator situation in Virginia, the Virginia Healthcare and Hospital Association, VHHA.com, posts a detailed list of how many ventilators there are in Virginia, how many are being used, and the number of available beds across the state. We have, as of yesterday's webpage, the update was 2,500 available total ventilators, and we were using about 700. So we were only using about 27% of our capacity. It also listed bed capacity, available beds in Virginia, which was more than 5,000, and probably in your systems across the state, as are mine here, that the emergency room is fairly very low volume, and the hospital is mostly empty, as we are not doing anything other than crucially necessary.